My name is Paul Dembling. I served in the government, or at least the collection that I've donated to George Washington University Law Library represents the personal papers of a career spanning some over 50 years in the executive branch of the federal government, in the legislative branch of the federal government, in academia, since I taught for some 21 years as an adjunct at George Washington Law School, and 20 years in private practice with the firm of Schneider, Harrison, Siegel, and Lewis. In the executive branch, I occupied more important jobs were as general counsel or legal advisor of the National Advisory Committee for Aeronautics, which was the quasi-federal government agency that did all research on aviation. That included aircraft, airline matters, and also air engines. It was an organization with about 8,000 people and had three major research centers, which later became the research centers of NASA. At NASA, I was Deputy General Counsel, an Assistant Administrator, Director of Legislative Affairs, and then for a while I occupied a policy position as Director of Policy Affairs. But that was, I think, just for a very short period of time. Mostly I spent my career in the law, and that's what this collection represents. It represents personal papers which I accumulated over the years, and includes material that I generated in terms of speeches, drafts of material. It does not represent actual cases that I had in private practice, because that was property of the organization with which I belonged. It does not also represent any governmental papers as such. Those belong to NASA or to the GAO, and those are not the papers that I have. There are papers which I have, and if there were anything that the government wanted, they got copies of it, and I've also, through Alan Stipek, made arrangements with the Library of Congress to have copies of those papers that they were interested in. And so this represents a collection, a variety of materials, esoteric materials, and personal materials that I've either collected or generated over the years. Articles that I've written, speeches that I gave, notes that I made in connection with talks that I gave, that sort of thing.
Does the archives have the material relating to the 1958 case and the drafting of the laws for the creation of NASA in this?
Yes, the archives do include all of the material surrounding the drafting of the National Aeronautics and Space Act of 1958. As you know, I was a principal drafter of that, and it came about because the Russians had orbited Sputnik in October of '57, and NACA, the organization with which I was serving at the time, was doing a lot of space research. Some 20% or even maybe a little more of its funds were being used for space research. So many of the people within the organization, the scientists and the engineers, felt that NACA was a logical organization to continue the space research that was going to be necessary and to carry on whatever activities there were in outer space. And the thought was that the heads of that organization at the time should make a real aggressive effort to obtain that mantle. At the time, the chairman of NACA was Dr. Jimmy Doolittle. He gets a lot of credit for being the head of the 8th Air Force during World War II, or the lead bomber of Tokyo. But many people don't realize that he had an earned Doctor of Science degree from MIT and was instrumental in getting one of the oil companies, Royal Dutch, to start producing aircraft gasoline, high-octane gasoline, for use. At that time, when he was an early bird, as we used to say, the thought was that aviation was going to be for the sportsman or for the rich sportsman, and consequently there was no need for more work to be done. However, he recognized the value of it, and as a result talked Royal Dutch into Royal Shell, I believe it was, talked them into producing high-octane gasoline. As a result, it made the company a very dominant company in the field, and he prospered as a result of that. He was the chairman. NAC was organized like a private corporation with a board of directors and a chairman and a CEO. The director or the CEO was Hugh Dryden, and the young people in the organization felt that they should take an aggressive lead in trying to establish NACA as the organization to do the future research and development in space.
What years was that, the NACA?
That was, of course, between October 57 and 1958, right. The period when after the Russian Sputnik, and lots of agencies within Washington were seeking that mantle. The Air Force, of course, the Atomic Energy Commission, Admiral Strauss, who was, or Strauss as he prefers, was head of the AEC, and felt that all exploration in space was going to have to be done through nuclear power, therefore felt that his organization ought to be, and NACA. The Young Turks, as they were known within the organization, had a dinner meeting with Doctors Doolittle and Dryden and urged them to move forward. I felt that I was not a scientist, I was not a technical engineer. How could I contribute? So I asked Dr. Dryden if I could take a little while off and draft a piece of legislation with the argument that Washington moved on the drafts that they saw, or at least the first draft, and consequently I did a draft, revised it a few times, and presented it, and that's the draft that was acted upon, and the functions that I drafted in there was changed only by a couple of words.
Were those words of any significance?
It wasn't great significance. One of the thoughts was that NASA could receive gifts, and Senator Clinton Anderson felt that does that mean, when we were testifying, does that mean, as he put it, that General Electric could send in a gift and designate it for you, Mr. Dembling. And I guess the language was a little broad, so he wrote that it had to be unconditional gifts to the organization.
At any time, did you feel that any of the original draft that you wrote was not appropriately put into place? Was there anything in its final draft that you felt something you had originally written should have been included?
All of the original functions were included. Right. And I wrote those based on an interesting way because, well, two things. One, at the time, there was arguments within the government as to what were delegable powers of the head of an organization. Could he delegate some things, or did he have to do them himself? Did he have to sign off on such activities? So instead of saying that the administrator should have the authority, what I did was to say the administration shall have the authority. Some people feel that that was a mistake and say it was a mistake, but it was not. It was put in there purposely to overcome the problem of delegability of a head of an agency. Secondly, what I did was I went through all of the General Accounting Office decisions that had to do with authorities of agencies and the expenditure of funds. GAO is really the last resort within the government as to whether an agency can or cannot expend funds for a certain project. And as a result, any time that the decision said, yes, the agency can do certain things because it had certain words of art, I wrote those in. If it said they couldn't do it because they didn't have certain words of art, I made sure that I covered that with the words of art. So NASA has one of the broadest authority in way of an organic act of any agency. Later on, the Federal Aviation Agency copied its act from ours, but it was approved and sent on to the President. Of course, it was signed into law by President Eisenhower after he had decided, with the I guess recommendation from his scientific advisor, Dr. James Killian, who came from, I think, MIT, who recommended a civilian agency. And NACA was the agency on which NASA was built.
Now, when you wrote the original draft for the creation of the agency and went to the subcommittees or the Senate committees for passing of it, did you meet any real resistance from anybody there?
Well, there was real resistance on the part of primarily the military departments. They were concerned that, first of all, that they should have the authority, and secondly, their argument was, well, you're giving it to an agency that hasn't had large weapons development capability, and therefore anything that was going to be used for orbiting or launching of missiles would require the kind of experience and contracting ability that the agencies have. Let me give you one example. The time of when we were trying to convince the Congress and others around town that NACA ought to be the agency of choice, a member of the committee, the Armed Services Committee, said, I will meet with you, but I don't want to meet with you in my office, and I don't want to meet with you in your office, because I am concerned that the legislative liaison people from the Defense Department, primarily the Air Force, will see us and accuse me of buying your arguments. So we used to meet at the Carlton Hotel, and we used to meet one of the government contractors, Victor Emanuel, used to have a suite there, and he used to come into town frequently. And whenever there was something to pass on to the member of the Armed Services Committee, he was a ranking member, I would let Emmanuel know, and the next time he was in town, I would meet with the member of Congress. So yes, there was a strong. That epitomizes the feeling that here this little small civilian agency was trying to capture this choice program.
Now, when you were creating the concept of the agency of NASA, the overview of it, there was a director, and then there were two separate entities that fed out of that, the scientific and the administrative side. When you were writing the laws for that, did you construct the entire concept of what the NASA flowchart would be at that point?
No. What I tried to do was to set down the authority of the agency. Really didn't organize, show the organization, but it did contain lots of the functions. It contained all the authorities, as broad as having economic authority, international authority. That was a controversial item, and because the original proposal was that NASA could engage in international agreements, and the State Department objected. And when President Eisenhower signed that bill, he took a reservation and said, of course, the international agreements are not solely the authority of NASA. It's understood that the President is responsible for foreign relations, and it's done under the aegis of the President, which is all what the State Department wanted, because then they were involved in that. They thought initially that there was going to be a separation from their input, so that covered, and that was a controversial item. The other controversial item was there is a provision in the Act for a number of what they call accepted positions above the classified level and above any other level in the government. The Civil Service Commission was doling out accepted positions to the various agencies, and we were afraid, or they felt that if we had our own, maybe they ought to take back whatever they had allocated to us. So there was a feeling there as to what was going to happen.
You told me in Anatoke when we had lunch that there was X amount of over G15 positions which you wanted to fill, and you went and negotiated. Would you like to?
Well, that came later. That came much later, and that came as a result of a site survey team that had been looking for a research center. There were 14 criteria that had been established for what became later the Houston Center or the George Marshall Center. 14 criteria which had to be met, and the administrator had established a site selection team, but he did not want to be called for their itinerary. So he gave that responsibility to me to determine where the team would go, or they can choose their own, but I would know where they were and who was going to see them. Congressman Jimmy Morrison from Louisiana was running. It was the only time we did anything politically. Usually NASA was a non-political agency. The people who were in charge were both Democrats and Republicans. No decision was ever made on a political basis that I'm aware of. In this case, we were asked by various congressmen to have the team come into their district because they were meeting the requirements, the 14 criteria. So when Jimmy Morrison asked about this, the team was going to be in the area. They were going to be in Alabama, and they were going to be in various other. One of the criteria was that it had to be near water that could be used for shipping large missiles, and it had to be in a warm climate. It had to be near university. Those were essential kind of criteria. And they went in and while Louisiana, of course, didn't get it, at least we had visited his district and satisfied his request, as we had done in a variety of wherever the place met the requirements. Later on, maybe a year later, 2 years later, we were seeking an increase in the number of accepted positions, and I went up to the Hill, and the bill happened to be laying on Jimmy Morrison's desk because he was acting instead of the chairman of the Civil Service Committee, who was not feeling well at the time, and consequently Jimmy Morrison was acting in his stead. And when I came by to ask about that, he asked, well, what were you thinking about? And I told him 400, so he wrote instead of the 1, which was 125, he made the 1 into a 4, and he says, I don't forget my friends. So it was one of the few times when there was a quid pro quo that I can remember, which was interesting.
And you ultimately used all those positions in a variety of
yes. They were used for administrative, and it helped recruitment tremendously and retention of high scientists. As the program started moving, what you found was that the companies wanted to steal most of the good people from NASA, and through these meeting at least some of the salary requirements, we were able to keep.
Would that become an issue? I mean, we didn't bring this up when we spoke before, but was there a lot of headhunting going on by the major corps?
There was always headhunting. Look what's happened in the last few years. Tremendous exit from NASA into these companies.
In the private sector.
Private sector.
Yeah. Was there any restrictions put on the scientists when they originally joined in 58, 59 as to their obligations?
Not to stay?
Yeah.
Not that I remember.
Did that create any kind of difficulty in the development of the respective missions, because there was always this remote possibility, if not remote, this possibility that a key individual might leave, taking with them the structure?
Well, not the structure. They would certainly leave with the knowledge of what was going on.
Yeah.
But there wasn't really that much secrecy with regard to any of the projects, and private industry knew pretty much. And of course, there was an awful lot of contracting with private industry. NASA's approach to handling those kinds of projects was that if they would try to get something working, operational. Once it became operational, they wanted to turn it over to private industry. For example, communication satellites. That became operational, was turned over. Meteorological satellites became operational. NOAA does meteorological satellites now. Landsat, which is a remote sensing and picture taking of things that you see from satellites, and very carefully documented, and you can identify lots of things from space. That's been turned over to, at one time, to the government agencies that were responsible. So,
when you were negotiating the contracts with these respective companies, was there very strong restrictions put on the use of the material that you were developing for them subsequent to the use in the NASA program?
no, if there was, that was one area, when you asked was there anything that was left out that was not included in the original act. The original act did not include anything for patents, and the reason for that, now known as intellectual property, and the reason for that was that if you didn't include anything, then the contractor who worked on that, even with government funds, would own the patent or title to the invention, as we say, but the government would get a royalty-free license to use it forever. The Congress, particularly the Senate, was concerned. They had just enacted the Atomic Energy Act, in 1954, so this was only about 4 years later. And they were concerned that here was another hostile environment, and maybe what they ought to do is make sure that there was title to all inventions that were, or even innovations that were coming out. Well, that was a proposal of the Senate, and in discussing it with them, felt, well, maybe you're making it too restrictive. Maybe what you ought to do is provide for a statutory board of inventions and contributions which could waive the title if NASA or the government didn't find that it needed it or wanted it. So that was what was done. And later on, the Inventions and Contribution Board would waive title where they felt that it was not necessary. In connection with that, you recognize what happens is that where the government takes title to inventions and warehouses it, nobody really uses it. The thought was that if the government had it, everybody would have it. The public would have it. Well, it doesn't really work that way, because what happens is it gets warehoused. If somebody doesn't have exclusive rights to it, why should they spend money? Because his competitor can come along and pick up everything and be as successful, if not more successful. So NASA developed a procedure where we gave an exclusive right to the contractor in whose jurisdiction the invention was first produced, and said to that contractor, if you want the exclusive use of this, you have to work it. You have to do something with it. You have to develop it, and we'll give you 3 years to do that. If you don't do it within 3 years, we'll take it back and give it to somebody else, or use it in some other fashion.
So when you were originally setting up the criteria for the structure of NASA, did you have, prior to that, the entire organization chart prepared? You already knew where the department was going to go? Or was the charter, more important, the original laws, drafted prior to the creation?
Oh, yes. Yeah. Well, yeah.
So,
actually...
What did you use as a point of reference then when you were writing it? You didn't even have, if you didn't have
Well, I
an
used
organization
the old
chart.
NACA charter and the old NACA Organic Act, and it didn't recognize, you can't recognize it really from the current NASA Act. There were certain things in there in the original NACA Act that was carried over into the NASA Act, but it was broadened, and I took a look at some of the other organic acts of other agencies and followed the general pattern, the purpose of the organization, the functions of the organization, and maybe relationships with other organizations. So in the development of the functions, I wanted to make it as broad as possible.
Did you have a preliminary size of what you wanted the agency to start at as far as staffing? Was there any?
No. It was. You see, when the agency started in '58, Keith Glennon was the first administrator, and he came in, and they started working on the smaller satellites, and they were working on the smaller capsules. The Mercury program, later on the Gemini program, and consequently it developed as the appropriations came along.
Right.
When James Webb was appointed, and he was appointed in the Kennedy administration, he came on board late February 14th, 1961, and by March he had gotten the view of the budget to increase the allotment for NASA to go forward to the Congress, and by May, I think it was, he had doubled the budget, and then people within the organization was already working on a project of going to the moon, and they took that over to the president, and it was that really started moving the appropriations, and that of course expanded the program. At one time there was an estimate there was several 100,000 people working on the space program. I don't mean in the government, I mean contractors.
Right. So when you initially started the program in 1958, what was your startup, what was the official amount of people working,
well, it was,
directly?
The NACA people were 8,000, and we picked up the Army Ballistic Missile Agency that was in Huntsville. And also,
that's the genesis of Huntsville then for NASA.
Right, right. That was the old Von Braun group, and also the Navy group that was working on, if you recall, they were the ones supposed to be sending up the first satellite. They were embarrassed by the orbiting of the Sputnik. This was
was that Wallops Island?
Pardon?
Were they stationed? Is that Wallops
No,
Island?
that was Wallops Island was always NACA and NASA. This was at the Naval Research Laboratory here in Washington. And they were working on a satellite under, at that time, the International Geophysical Year. And initially, when Sputnik went off, there were some people who felt that, including the president, that was Eisenhower, who felt, well, that's not a big deal. But then when they recognized what the capability was, and the ramifications, then they got real serious.
So based on that circumstance, what was your initial request for appropriations for creation of the agency? And, I mean, you told me the story how it increased. I mean, this is probably a good time to go into that. That
was, I don't remember the amount with regard to that, but once the program to go to the moon was established, then the Appropriation Committee wanted to know what were the run-out costs. What is it going to cost us over the whole decade if you do launch and you are successful to go to the moon? What is your success going to cost us? And the man who was heading that program at the time, Brainerd Holmes, came up with an estimate of about $10 billion for the 10-year period. Jim Webb, the administrator, felt that that was not enough. He didn't think that that was a good estimate. He told them to go back and study it some more. They came back with $13 billion. When we went up to the Hill to testify, the chairman, Albert Thomas, asked, what are the run-out costs on this, Mr. Webb? And Mr. Webb said $20 billion. Going back in the car, Brainerd Holmes said, where did you get that number from? Well, Webb said, well, he put an administrator's discount on it. However, what I knew was that he had been reading lots of material of reports of weapon systems and the costs of weapon systems and the overruns that were occasioned by those systems. And one book in particular was greatly influential with Webb, and that was a book called Weapons Acquisitions by Peck and Scherer. They were professors at Harvard who had taken a lot of weapon system programs and shown how they had overrun each time. And then Webb took the amount that they would overrun added it to the 13 billion that he got from his staff, and that's how he got to the 20 billion. It was brought in under the $20 billion, and Congress still is asking how come NASA can estimate it properly and most of the other agencies can't. Senator Proxmire used to use it all the time, when he used to award his Golden Fleece Award. He used it all the time.
So in other words, NASA had enough common sense to realize that no matter how you spun it, the military-industrial complex is always going to overrun for whatever particular reason, be it windfall or just misapplication. So it was a safer idea to expand the request for money, knowing that you could contract it if it actually happened.
That's right. The problem, of course.
And one quick question before you answer. Were you required on an annual basis to match funds for the previous year, or did they give you an flexibility?
Well, there was a flexibility. Some of the funds were what we call no-year funds. They're available until expended for that project. They also gave us some authority for reprogramming. So you could take money from one program and put it in another program if you need it. That was limited. But at any rate, there was that flexibility.
It does relax a lot of apprehension when you're doing your work.
Right, when you can't hit it right on the nose.
Okay, you were going to say something else before I interrupted you.
What I was going to say was with regard to the Apollo program, bringing it in under the $20 billion was an achievement, and it was recognized as such. But also, one of the problems that is true even today is that an agency wants to shave it down so that they get approval from the Congress. Congress doesn't like big numbers. The agencies aren't going to get big numbers. And so always, every year, they're going to cut the budget, they're going to cut the appropriations, and so they try to cut each one. So what happens is the agency buys in cheap, gets the Congress to commit to a program, and then feels that they can get the follow-on money if they underrun or if they overrun. And the Congress many times knows that they're buying in cheap, but they're doing it because it looks good on their record. And I suppose that they don't like to hear that said, but that's really the reality. And the agencies know that, and the agencies know that it's going to cost more when they many times project a figure, and the Congress knows that it's going to cost more too.
When you were writing up the respective contracts or the drafting whatever laws that Congress would have to enact, did you make sure that you restricted them from not having wiggle room to get out of those circumstances? Whether the Senate could or whoever could get a way out if they decided they didn't want to deal with an overrun?
Well, what the Congress makes its own situation. Usually, funds are appropriated on a fiscal basis, on a yearly basis, and so they got lots of wiggle room. In other words, if a program doesn't work out, they can just cut it off. They don't have to appropriate and continue the program. The Apollo program was an unusual program because once the commitment was made, it was sort of understood that they were going to carry it through. The president had said that we want to do this within this decade, and
being Kennedy.
Kennedy wanted to do it within this decade. So once they started appropriating money, it was sort of a little bit of a commitment. But they had the authority at any time not to appropriate money. There was some money, as I say, which was no-year money, which we had for the run-out of that program. So that was all.
During the 60s, was there any annual problems you might have based on the Vietnam War, where the use of money might be too radical, let's say, in relation to what the war effort needed? Or the apprehension? Let me answer that portion first.
Yeah, I don't think that there was. I don't remember that there was a big problem in that regard. In other words, you have to support a war, or are you going to support the program? I don't think we felt that as much. There was an effort to cut out other programs and give priority to the Apollo program, so that those other programs within NASA, those were felt, and there was some, moving down of the priority list of certain programs.
Were there any programs that were aborted because of lack of funds, which ultimately should have been taken to conclusion?
I don't remember, and that's more of a question that the technical people could answer, and I don't, none comes to mind. I do know that aeronautics, for example, didn't get as much as they wanted for aeronautics, and everyone used to say, don't forget, the agency does have not only space but aeronautics in its not only title but responsibility. That program suffered some, I think, and there were other programs that suffered if it didn't come under the aegis of space and it didn't come under the aegis of the Apollo program.
Right. Was there a lot of infighting then between the different respective sub-departments?
There wasn't infighting as much as there was competition.
Right.
There was competition between the Houston Laboratory Research Center at the Marshall Research Center and the Langley Research Center, and with regard to programs and things that were done. Maybe you might call it infighting. The one program, the one thing that I do remember was there was thought that a large pool where you could train astronauts to experience some weightlessness would be built. Was not supposed to be built at Marshall. Marshall and Houston were the two big competitors, and they felt, Houston felt that it should have it, Marshall felt it should have it. The decision was, as I recall, that Houston would be the center, later called the Johnson Center. And Marshall went ahead and built the thing. Surreptitiously said, "Hey, look, we did it."
With funding that they had out.
Well, they had used funds. So there was that kind of that was the most egregious one that I can remember.
As chief counsel, were you responsible to mediate in these internal problems if they occurred, keep them from the general public knowing, because you didn't want any publicity to be negative as far as the program was concerned?
Not in a technical sense. That was really one of the jobs that either Dryden or Siemens, who was associate administrator, Dryden was the deputy administrator, or Webb. But usually one that Siemens would operate on. And I do remember one situation which is sort of an interesting one, and that is the administrator, Mr. Webb, asked me to sign off on launch schedules. And I said, I'm not a technical person. I don't know whether a launch ought to go forward or not. He said, well, if you don't see anything that troubles you, sign off. What do you care? So I kept signing off. Then once one of the launch schedules said that there had been an agreement for tracking arrived at between the director, the associate administrator for manned space, George Miller, and Jim Clark, who was the director of Goddard that handled the tracking. I said, gee, I haven't seen an agreement for tracking. I'd like to see it. So I called up Goddard, since they're right over here in Maryland, and said, Jim, can you send me a copy of that agreement? He says, there isn't an agreement. George and I can't agree as to how the tracking's going to be. So there's no agreement. I said, well, it says on the launch schedule there's agreement. He says, that's not true. So I non-concurred. And so I sent it up. When Webb finally got it, he called me and he said, now you see, Nobody else would have asked to see an agreement. Only a lawyer would have taken a look at it. And so now you understand why I wanted you to sign. He said, I didn't know why originally, but I knew there would be some time that you would contribute.
Yeah.
It was an interesting...
Well, it makes sense, because you would think, based on the size and the scope of what the agency had, that there would need to be legal decisions made almost on a daily basis.
Well, yeah. I'll tell you another aspect of the legal. This came up really later on during my term at GAO. When I first got over to GAO, General Accounting Office, the Comptroller General, who's the head of the GAO, sent me, I was General Counsel there, sent me down a draft report that one of the survey teams had written and asked me to comment. So I commented on it, and not only about some of the legal problems, but generally. And sent it back to him, and of course the division director got a copy of my comments. He called me up and he said, why are you commenting on all these other things? You're supposed to only comment on legal sufficiency. Well, I told him why and so forth. And so he said, well, I'm going to raise it at the division director's meeting, which he did. And when he raised it, Stotts, who was the Comptroller General, turned to me and said, what do you have to say? Do you have any comment? I said, I do. I figured it's my job always to protect the boss, and if he sends me down something to comment, if I see something that I don't think is proper, I'm going to comment on it. And then to end it up, and to make it a little lighter, I said, and besides, I'm not legal counsel, I'm general counsel. So later on, as a result, if I ever said there wasn't a legal problem, they'd say, I thought you were general counsel.
Now, when NASA was finally appropriated the money and you went forward in '58, President Eisenhower was highly supportive of the agency at that point. And then obviously went into the Kennedy administration with the same dynamic, if not even more interested. We spoke, and you said that after the Johnson administration, when you reached the Nixon administration, there was an acrimony with Nixon because he was angry because Kennedy was the creator of the program.
Initially, he felt that this is a Kennedy program. So when he came into office, and of course, just before that, Webb had contacted the Nixon people, and he'd contacted the Humphrey people, and said, look, I think that NASA ought to be non-political, and it should have a head that is a non-political individual, and I'm going to retire, and I'm going to resign before the election.
Well, before we get that, we should say Jim Webb was the director from 1961 through 1968, pre-election. Right. So he had been under both the Kennedy and the Johnson administration.
Right.
And he was he a political appointee, or was
he was a political appointee.
Right. How many political appointees were given positions in the...
There were only two political positions in the agency, the administrator and the deputy administrator. The deputy administrator had been the director, a career individual who had been the director of NACA. Prior to that, he'd been the deputy director of the National Bureau of Standards and had a big international reputation, inventor of lots of systems that were used during the war, the BAT being one of the major ones that he was involved in. So when Webb went to Humphrey and Nixon, people said, look, I'm going to resign before. I think it ought to be a non-political position, and consequently I think you ought to decide who it is beforehand so that I can brief him or her and make that decision. Well, it wasn't acted upon. He did resign in October of '68 before the election, and then Nixon was elected. When Nixon went out to try to fill the position of the administrator, we saw a list of some 30 people that he had asked. And when we asked some of those people who turned down the job, they said, well, he didn't want to make any commitment to us. as to whether he was going to seek funds for the... He said, what we heard was, it's a Kennedy program, it's identified with Kennedy, I don't want to have much, I don't need to support it. However, the men who landed on the moon landed in the administration of Nixon in July of 1969.
I was going to say that 16 months subsequent. Oh.
That's right.
Yeah.
And so consequently, he then wanted to run a big celebration, which he did. And of course, they recognized that it was done in his administration, so he got credit.
Did he then revitalize the use of appropriations because he saw the public relations?
Well, by that time, he had already appointed Tom Paine as the head, and Tom Paine served out, and then later on there were Republican...
and then it became politically... Was that not politically charged?
Not really.
Not really. So
No, just the individual as to his registration, and they were all qualified individuals, all scientists, all people who had made a name for themselves.
I always felt that NASA were many voices, one goal. You could see that there was a real dedication to the program, regardless of what your political aspirations were.
Well, as I say, there were only 2 political appointees. I mean, only 2 presidential appointees. And all the others were either appointed by... and it's interesting, the director, the head of administrator and the deputy administrator were nominal Democrats at the time, and the associate administrator, who was really the CEO, the operating head, who was Bob Siemens, was a Republican. He later became Secretary of the Air Force, and during the Vietnam crisis, or at least part of that time.
Let me ask you a question. I think you've given us pretty much a fairly comprehensive overview of the program. When one is using the archives, is there anything you should be focusing on for disseminating the information? Is there any particular area you would say to look at?
Well, it depends on the since it's a variety of aspects. If you're looking at some of the space activities and papers, some of the materials that were collected in connection with the... I gave 2 courses at GW. One was the first course, I must say, in the law of outer space activities, and the other one was the legal hazards of in technology. I didn't give that more than a couple of years. I couldn't just do both of them and a full-time job. So that one was dropped. Actually, Professor Brown took it over and ran it during the day for the most part. The law of outer space activities, it was a research program, seminar, and research. And a lot of those research papers are very good, and those are included in there. A lot of them.
Does it take into consideration the concept of private sector getting involved in projects which the government has particular interest in, as far as what the law will allow? I mean, does the federal government have a restriction, allowable restriction upon private sector to enter space in any particular way?
Well, not anymore. There are aspects of it with regard to the treaties that have been signed, so that if there's an organization that operates out of a country, that country's liable for its activities. So there is a certain restriction under whatever laws of that country. But for the most part, one of the restrictions is the cost of trying to launch something. So that most of the launches are either done by NASA, most of the commercial launches are NASA, or they go elsewhere. They go to China, or they go to Europe with Ariane, which is a conglomeration.
I mean, it's interesting. I just was doing an appraisal unrelated to this on moon dust, and there's a company that's actually selling acres on the moon right now, with the understanding that they are going to be the first private sector company to land on the moon, and they feel they're going to get something similar to like the Oklahoma Sooners. You know, there'll be a land rush, and they'll be able to take that land.
Not under the Outer Space Treaty of 1967.
Right.
There is no appropriation. There can't be any appropriation.
Right. That's what I felt. You know,
and I don't know where.
Monica or what.
Either somebody's scamming them.
Sure, it's selling land in Florida.
Right.
But I mean, that's my primary reason for asking the question, is that in this archives is the preliminary structure for the space law, which is now in effect.
Yeah.
So you were there, if not writing it specifically, you were collaborating with other individuals for the original space laws as we know them.
Right.
So to the present time, the whole historical background
is in there. And I did something else also. At the time that I served as a U.S. delegate to the United Nations, to the legal subcommittee, which had jurisdiction over writing the space treaties. This included the Outer Space Treaty, the Astronaut and Rescue Treaty, the Moon Treaty, and so forth. What I also did was, since I was there, I wrote several articles as to what was considered at the legal subcommittee, so that not only are the materials there, but the articles that appeared in the Journal of Air Law and Commerce at that time covered the debates and the arguments and the proposals of various countries. At the time that I was there, there were the various countries represented on a legal subcommittee. I think there were 52. And as a result, lots of countries had their own view of what should be protected, what should not be protected, how it ought to be protected, and proposed language for that, which was debated hotly and heavily. And as a result, what I wanted to make sure was that there was a legislative history to show how you came to where we finally came to. And since that was not written up in the original materials, I wrote some articles that cover that. And those articles are very valuable for somebody who wants to know how did you arrive at whatever language there is in the Outer Space Treaty today.
Did that take into consideration circumstances like the demise of the Soviet Union, or a program which was not as advanced as ours, as we found out subsequently, but now is in shambles, when they must have been the second major player in the negotiations for the
Mir, which is coming down today, by the way, was an advanced program. It was pretty good. And some of their original communication programs were fairly good, as I understand. But there was never any thought out, with regard to that. The only feeling was that space was for the benefit of all mankind, and so that the small countries were always concerned that the large space powers would not have all the authority, and they would not have all of the clout, and they would not have all of the program, that they should be able to share whatever is discovered. And so when the moon rocks were brought back, every country that wanted them for scientific research got some of them.
With justification, though, right?
With justification, yeah, right.
Because now they're starting to filter on the market, and this is speculation.
That's right. But at that time, so in order to carry out that statement in the Outer Space Treaty that it is for the benefit of all, even the small countries got their share, got the information, and that sort of thing.
I'm almost embarrassed to ask this question if I have to. Was there any structure put in for extraterrestrial contact?
Not in the space treaty.
No, there's nobody really. Would that ever come up? I mean,
well, it came up as to whether that was something that ought to be covered, but never. And there were programs. You know, Carl Sagan spent a long time on that feature, and the National Science Foundation had a program I don't know whether it still does, but did have a program trying to make contact, radio contact, with whatever might be out there.
Right.
And Carl Sagan, by the way, came from my hometown.
Really? He's from Raleigh?
Raleigh.
Oh, it's a center of brilliance then. Okay. Next up, we've covered probably everything unless you have any specific points of reference you want to tell about the archives that people who might be utilizing it should look out for in any other respective area of your career. We'll focus most on the space program.
Focus mostly on the
space program.
On the space program. Could cover some of the things with regard to GAO, and there were a couple of major programs that I might mention, and that was going back in history. Every president from George Washington on has impounded funds that have been appropriated by the Congress. In other words, Congress appropriates a certain amount of money for a program or to an agency, and the president said, well, you know, they've appropriated a little bit too much, or I don't want that much spent, and that sort of thing. So this was sort of understood. Congress appropriated, the president didn't like some things, he'd hold back and he'd impound the money, as we say. Consequently, when Nixon became president, he started impounding a lot of programs, and he was impounding big money. And by that time, I was in GAO as general counsel, and that's a legislative agency. That's the reason I said that I served in the executive branch and in the legislative branch. GAO is is an arm of the Congress, and as such is in the legislative branch of the government. So the Congress kept saying, you know, we've appropriated money, and he's cutting the heart out of these programs. So we took some of those cases to court. There were about 20-some cases, and one after another, where the court said, no, the Congress has appropriated money, and you have to use it. There came a time when he impounded the whole appropriation for an agency. Economic agency. Can't remember the full name of it. But at any rate, when you impound the whole amount, that means the agency is going to go out of business and can't have any fun. That really riled the Congress. As a result, what they said is they enacted what they call the Impoundment Act, I think of the Impoundment Act. 74.
74.
What it provided was that the GAO would have responsibility to determine what was being done really. The executive branch could defer a use of money. They could request a repeal of that money, but they couldn't impound without making a decision as to how they were going to handle it. And GAO was supposed to go in and check to see whether what they were telling the Congress was correct. And so that's what it was. There was an impoundment that involved the secretary, the HUD, the agency, HUD. The secretary of HUD at the time had impounded funds, and GAO felt that it was improper. The secretary then was appointed to be director of the Bureau of the Budget, and Carla Hills was named secretary of HUD. She wanted to settle that matter and start spending some of that money, but he was now he was now director of the Bureau of the Budget, so he said, no, you don't do that. So we sued, GAO sued President Ford, and Justice was upset. They don't like a president being named in a lawsuit. So we got an agreement that whatever the court would hold would be binding on the Secretary of HUD. And as we settled the case on the steps of the courthouse, literally. We would have liked to have established definite law, because the courts would have written a long decision on that. Would have been a case of first impression. But at any rate, it was settled, and that was an interesting situation. The other one was more of a personal situation with regard to how you interpret a piece of work that one is doing. When a proposal was written in the government and contractors bid on it and an award was made, occasionally there would be a mistake made by a contracting officer. Either that he made it improperly, or it was illegal, or one thing, he didn't follow the rules or something. And consequently, it was decided that that should be overturned. Now, previously, such contracts were canceled. And when I got over there, I said, when you cancel a contract, that means that the contract was void right from the beginning, as we say, ab initio. And if the contractor had been paid anything, he had to pay it back to the government. And many times he was not the culprit. Why should he suffer if there was some wrongdoing on the part of or improper activity on the part of the agency? So I pushed to have it considered an improper act, and instead of canceling the contract, those are legal words, cancel, as against terminate. If you terminate, then the contractor gets paid for whatever he did up to the point of termination, and he doesn't suffer as much as if it were a cancellation. It took a little while, but we finally got a decision through that established that policy, and that policy now is all the way through, and I was sort of pleased with that.
And that archival information is
present in this
collection?
That's in there, yeah. Good.
Okay, is there anything anecdotal in either the space aspect of the archives or in the GAO aspect that you would like to bring up?
Well, just a couple of minor things, or quick things, short, brief ones. NASA was the first to try out awards contracts. This is something that government contractors now are familiar with, but it was established in order to evaluate how well a contractor was doing, and rather than to say whether when you meet certain requirements you'll get bonuses or whatever the incentive contract stated, this was a way of saying, look, we're going to evaluate you totally with regard to your performance, and we'll give you it's like what we call the report card. And from a managerial standpoint, we'll make a unilateral decision as to what you ought to get as a payment. And that was established, and it worked very well, and it has been working pretty well. And I think it worked very well because the first contract we worked it on was a very successful contract, and the contractor was happy, and we were happy. So that was one aspect. I guess others are pretty much we've talked about various matters.
Good. Okay, is there anything in conclusion you'd like to say about the collection, or any advice you might want to give to anybody that might utilize it?
I hope that the collection will be indexed or properly indexed, so that people will be able to find things readily. As I say, there are really four parts to it. There's the executive branch part, which includes most of the NASA period, and the NACA period, and some things that I had done before then, some articles and that sort of thing. Then, of course, the legislative period, where I served as general counsel of GAO, and the cases and the various materials. And by the way, there is an oral history that GAO had, and it was done in September of 1988, and it's in the United States General Accounting Office History Program, which may have quite a bit of information that was not covered during this comment. And in connection with the NASA drafting, there is the legislative origins of the NASA Act of 1958. It was an oral history workshop that was conducted April 3rd, 1992 by Professor John Logston of George Washington University, who's head of the space policy group at George Washington. And so that may be of help also. And as I said, that there are articles with regard to the NASA program. And then the GAO period also covered my activity in the bid protest arena, and articles that I wrote about bid protest and the government relationship with the GAO relationship with government contractors, and then my period in the private practice, where there are a variety of articles and comments and statements that are made. Also, I see that you brought the item from Goddard Space Flight Center. There is a website, I guess it's called, and if somebody is interested in contracts for technology ventures, that's the subject of this. It's called Conducting Business with GSFC via a Space Act Agreement. What I'm pleased about is that they talk about Space Act Agreement. This is one of the functions of that's listed in the NASA Act. It's 203B5, and it says, this is Goddard's writing, it's not my writing, it says, Space Act agreements come in a variety of forms, are executed with a variety of different entities, and are used for a variety of different purposes. Chief among the distinguishing characteristics of such an instrument is the fact that NASA does not provide funds. In most cases, NASA receives some benefit from the arrangement. Why are they called Space Act agreements? NASA's General Counsel, Paul Dembling, drafted NASA's original authorizing legislation, the NASA Aeronautics and Space Act of 1958, now codified at 42 U.S.C. Sections 2451 through 2484 as amended. Due to Mr. Dembling's genius, this organic statute contains particular language providing NASA with tremendous flexibility in entering into certain arrangements. Section 2473C5 of the Space Act provides the administrator of the agency with the authority to enter into and perform contracts, leases, cooperative agreements, or other transactions, that also has been controversial, as may be necessary in the conduct of its work, and on such terms as it may deem appropriate with any agency or with any state or with any political subdivision or any person, firm, association, corporation, or educational institution. Then it goes on to say, this authority has been used by NASA to accomplish goals it could not have accomplished through traditional procurement arrangements and which other agencies might not have been able to accomplish. As the statute indicates, NASA can enter into such instruments with a variety of institutions for a variety of purposes. And then it goes on to detail it, and you can get the full text of this on the website.
Very good. Thanks very much for consenting to do this, and I'm sure it's going to be a very reliable resource for anybody who uses your archives.
Well, good. Thank you.